Good evening, everyone, and welcome to our October 9th webinar with Special Education Legal Fund and Wealthspire Advisors. We're presenting special needs planning, and we have a great panel of experts with us this evening, moderated by Michael Delgass from Wealthspire Advisors. We are super pleased to welcome Adrienne Arkontaky from Arkontaky Law, Rich Yam from Wealthspire, and Marion Walsh from Littman Krooks. Sorry. Before we begin, I'd like to acknowledge our corporate partners without whom so much of what we do would not be possible. At the platinum level, I'd like to acknowledge the Eagle Hill School and Wealthspire Advisors. At the gold level, I'd like to acknowledge the Winston Preparatory School Group. At the silver level, Fusion Academy, the Villa Maria School of Stanford, Chapel Haven Schleifer Center, and American School for the Deaf. And at the bronze level, I'd like to acknowledge our friends at Greenwich Education Group, the Pinnacle School, and Spire School, both in Stanford. Thank you all so much for your support. For those of us who aren't familiar with us, the Special Education Legal Fund is a nonprofit organization that was founded in 2018 to provide resources, knowledge, and support to families in need with children in the special education system. We do this predominantly through two grants programs, the Attorney Grant Program and the Advocate Grant Program, that provide parents in need with access to a qualified legal professional in whatever capacity they need through a competitive grants process. We provide legal support and advocacy to families in Connecticut and Westchester County through both of these programs, and our website is there below. I'll show that later on if anybody is interested. First of all, the Legal Assistance Program and the Advocacy Support Program, or the Attorney and Advocate Grant Program, are currently accepting applications. The Attorney Grant Program provides families with $6,000 in legal support from a special education attorney, and the Advocacy Program provides families with $1,000 in advocacy support from a qualified non-attorney special education advocate. This process has 4 steps. To begin the process with a pre-screening application, please visit our website at www.spedlegalfund.org, and you will click on the orange button that says Apply for Grant. Really pleased to welcome for our next webinar, our school showcase with the Eagle Hill School. And this Eagle Hill is new to our school showcase program. So I'm really excited to welcome Gretchen Larkin, who's their new head of school, as well as their upper school head, director of enrollment, and director of language services. These school showcases are really something that we began at S.E.L.F because we realized that a lot of families don't have the opportunity to go and visit schools. They don't have the access. They can't take the time off work. And even when they do, it's difficult to know what to ask if you are going through the process the first time. So, we, really mean to stand in the shoes of the parents, ask the questions that parents want to know, ask the questions that, that I would want to know if I were looking at a school for my children. And I have done that. I think my kids have attended in total 9 schools, both independent and public, over the course of both of their academic careers. So I consider myself a little bit of an expert in evaluating schools. So that is the purpose of the School Showcase Series. We're super excited to welcome Eagle Hill to that, and I can't wait. If you'd like to register, you can scan the QR code or go to Eventbrite the same way that you registered for tonight's webinar. I would be remiss if I did not mention that our annual fundraising event is coming up on November 9th at the Arch Street Teen Center in Greenwich. This is Homecoming for S.E.L.F, and this is going to be really fun, casual, wear your college sweatshirts, just hang out and raise money for S.E.L.F. I just want to point out, due to some, an email I got earlier this evening, that this is an adult event. This is not for children. This is an event that we raise predominantly all of the funds that we use during the year for all of our programs, particularly for the Attorney and Advocate Grant Program. We are an all-volunteer organization. Nobody is on salary, including myself. And this is the way that we generate the funds that we need to keep the lights on and continue to give grants to families. So if you're interested in supporting our efforts to, keep helping families in Connecticut and Westchester, please, scan the QR code. And, we appreciate any contribution, no matter the size. So that brings us to the first of our distinguished panelists for this evening. This is, the third year that we've done this series, and, it's become even more popular every year that we do it. I'm particularly pleased with this panel because I really like to highlight not just expertise in these areas. Obviously, all of our panelists are experts in their field, but also I like to highlight experts in the field who have walked the same walk that each one of you has gone through. Our panelists have, experienced what you have. Most of them have children with special needs, special educational needs, et cetera. And so, that gives, them a very unique view and insight into, what we all are going through with our own children. So with that, I want to welcome Marion Walsh, who has worked in education law for over 20 years. I mean, the accolades are, extensive. I really, love having Marion on these panels, particularly because she has, a special expertise in mental health issues, and really, puts her money where her mouth is, and and volunteers with a lot of organizations that support mental health for children, teenagers, and adults. So welcome, Marion, and thank you for joining us again. Our next panelist, our second special education attorney on the panel, is Adrienne Arkontaky, and I'm thrilled to bring Adrienne back. Adrienne also has an extensive amount of special education law experience, also 20 years, and she also has and recently left a large law firm to start her own practice, the Arkontaky Law Group. I guess it's not recent; it's like over a year, but I just keep saying recent. Anyway, Adrienne's practice focuses on special education legal advocacy, litigation, as well as special education and special needs estate planning. And we're very, very thrilled to welcome Adrienne back to the panel. She is tremendous and a tremendous resource in this area. So welcome.
Thank you.
Rich Yam. This is also Rich's third, panel for S.E.L.F. And Rich is a senior vice president in trusts and estates at Wealthspire. Honestly, there isn't much that Rich doesn't know, just in terms of what, questions I've been trying to throw at him. About tax planning, long-term care planning, and estate and trust administration, particularly with a lens for families with special needs. So we're really thrilled to have Rich back on our panel, and welcome to the panel, Rich.
Thank you.
Finally, last but not least, fellow Hoosier, Special Education Legal Fund founding board member. I know I usually try to keep that on the down low, but it's all right. Like, it's fun to be Midwestern now. It's like it's in now. It's trendy. So Mike has a ton of experience in on the legal side as an attorney. He is also, as I mentioned before, I mean, you can read about his accolades. He's a founding board member of S.E.L.F. He's also the vice chair of our board of directors, and has been, pretty much since, the day we opened our doors. And Mike is also someone who walks the walk in terms of his own children and the needs that they've had, in the educational system over the years. So welcome. I think you're like 3 out of 4, Mike, on your kids. IEP 504.
Three IEPs and 1 504.
Oh,
so
perfect.
I don't know if that counts as 404.
Yeah,
404,
that's like batting 1,000 in
pretty
this
close.
This game.
Yeah.
So welcome, and he will be leading our discussion this evening. So before we begin, I'm going to read this disclaimer. This webinar panel is presented for informational purposes only. This webinar is intended as a resource for families who are navigating the special education system in Connecticut and New York, and is not intended to provide legal support, advice, or assistance to any particular individual, nor is it intended to replace the advice and counsel of a qualified special education attorney. This webinar should not be construed as an endorsement by Special Education Legal Fund or any of its representatives of any of the participating attorneys or professionals in the panel. For webinar participants, this panel should be viewed as a public forum. Please do not ask questions via the Zoom platform, either in the Q&A or the chat, about your child or your child's specific legal or educational situation. Please refrain from any comments that include identifiable information, including name, grade, school, or school district. Please remember that your screen name is visible to the participants in this panel, as well as the panelists and Special Education Legal Fund. This webinar is being recorded and may be distributed or shown at a later date at the discretion of Special Education Legal Fund. Should you have a question that you wish to ask one of the panelists, please email Christine at spedlegalfund.org, and I will pose the question to the panelists during the course of the evening. I will put my email in the chat, so no need to panic if you didn't write it down or I was speaking too fast. And with that, let's begin. Welcome, everyone.
Yes, welcome. Thanks very much, Christine. As Christine said, my name is Mike Delgass. If you want to get in touch with me, ask further questions, that kind of stuff, it's michael.delgass, my screen name with a dot in between, at wealthspire.com. But there's also a fair amount of information about special needs planning and other financial planning considerations on our website. Please go look at that. There's a whole series of videos also on LinkedIn from some of our advisors that focus on special needs planning in particular, which gives you an idea of what we do, right? So I'm a managing director at Wealthspire. We're a national fiduciary, that is RIA, independent registered investment advisor, that works in wealth management. And we work with people across the country and internationally, frankly, on investment management, estate planning, financial planning, special needs planning, and a whole bunch of other planning things, right? So the three kind of pillars of the work that we do are investment management, financial planning, which implicates a lot of special needs issues for many families, probably many of the families that are tuned in here, and also estate planning and other risk management, other things. The kind of other pillars is the third piece. So, as Christine said, I feel a real personal connection to this topic, and it's very important to me. I look forward to this webinar every year, frankly, because I think it's really important. And so I'm really glad that everybody joined us and that we have such great people on our board. So I'm happy to get to them. My role here tonight is to be you, that is to be the listener, to ask questions of our panel to help them get out the stuff that might be most useful to all of you. But there's a lot that they know that we won't get to. So you should also go and talk to them independently as those things come up for you. So Adrienne, I think we'll start with you. Christine gave you a great introduction that was very well deserved. But tell us a little bit more about your practice at Arkontaky Law Group. I mean, I think it's almost exactly a year, because I remember last year I gave you a like, hey, do you have an announcement for us to? So tell us about your practice.
So first I want to say thank you. Thank you for arranging this webinar. Christine, if I said thank you a million times for what you do, it's not enough, because it's just an incredible organization. So thank you again. And so I have this law group. It's the Arkontaky Law Group, and I was with one firm, as Marion knows, at Littman for 7 years, and then I was at Cuddy for 12 years, and decided, it was time to make a change. And so I have this incredible team of attorneys and staff who, God knows why, they put up with me for 10 or 12 years, but they came with me, and the vision really was to focus, to use a holistic view of planning. So we do special education law, which we'll never give up. Some of the practices in New York City, some is in the suburbs throughout New York State. Special education advocacy and litigation. We do a lot of hearings, but we also do a lot of special needs planning. And what that encompasses is not only the estate planning, it's transition planning, and also Office of Persons with Developmental Disabilities, the applications and the appeals, when there are issues, when there are kids. And I'm going to, talk about Marion because we live these parallel lives of knowing that, you know, we're the ones that are helping the families with the nuanced cases. And Christine said today, these are not straightforward cases all the time.
Yeah.
They're families who have like this plethora of issues applying for the eligibility. So my vision really was to create a team, and which I hope I have, to really holistically plan for people. So that's what we do. We're, you know, as a mother, I have 3 children. I always tell everybody I'm an open book. I have 3 children. I have twin grandsons. So my oldest daughter is a neonatal nurse. She didn't become a nurse by accident because my middle daughter, Jordan, has pretty significant disabilities and had nurses her whole life. So I always say Justine thought everybody became a nurse, you know. So she is a neonatal nurse in a high-level NICU. And then I have a 26-year-old who is really what I call the poster child for special education. So for people out there who are saying, what does the future look like? This was a kid who had significant learning disabilities, went to college, made the honor roll, went to Edinburgh to do her master's degree, still
Wow.
has the challenges to, you know, and she'll say, you know, she knows how to self-advocate, and became the stage manager in New York City at stage managing all these shows. And you know, we pinch ourselves that she did really well. So you know, the point really is, Mike, the long-winded answer is that all of us, I think, live and breathe this, but our children have done amazingly well, and there's still challenges because of the planning we do. So that's, you know, that's who I am, and, you know, that's what we
Li-
do.
I think that's a good segue to special education in particular, which is kind of this subset of special needs planning. Um, how does somebody enter the system? Can you tell us about kind of child needs and special
Yeah.
education referrals?
So, you know, the special education system really starts from 3 to 21 or 22 really now,
Mhm.
which is always a little bit dicey later on. But it even starts as early as EI, the early intervention here in New York, and whatever the equivalent is in Connecticut,
Birth to 3.
identifying as early as possible a child with special needs or special education needs. And, you know, while a child can go through EI, when the child turns 3, it is the district's responsibility. And Marion, as I told our presenters, I'm just battling a little bit of a cold and some coughing and stuff. So I'm gonna ask Marion to chime in if I forget something. But you know, at 3, the district really becomes responsible. Oh, and I'm a little
Mhm.
cranky, so I may, you know, I may blame the district a little bit because I think they're having more challenges these days. But at 3, it's the school district's responsibility under Child 5. Really go out and find every child who has a special education need. That means even a child who may be in a homeless shelter, who may be homeschooled, who may be in a private school, right? So it's the district's
Mhm.
responsibility. That's what the law says. But in reality, parents need to, you know, if they think something's
Right.
wrong, we are the identifiers. So we go in the district, whoever makes the referral, whether it's a teacher, whether it's the school district administrator, whether it's the preschool teacher, and gets the parent to consent to these initial evaluations.
The parent can
So
also make a referral, correct?
the parent can make a referral
Yeah.
also.
Yeah.
Thank you, Christine. So, you know, you have this sort of, you know, community of people who can make the referral. You know, a doctor can make the referral.
Mhm.
Whoever it is that makes a referral, the important thing really, and I always said this, I said this last year, I do remember this, is that, you know, we want to make sure that the parents sign the consent as early as possible, because the timeline, that 60-day timeline to evaluate and hold the CSE meeting really
Mhm.
starts when the parents sign the consent, not just when the referral is made. So that's an important takeaway, to sign the consent saying, yep, you know, you can go in and evaluate.
So 60 days is kind of the time frame for the initial evaluation after that consent is signed.
Yeah, yeah.
Okay.
45 days in
By the way,
Connecticut.
yeah,
Yes.
and remember, one of the disclaimers is I'm a New York attorney and I don't practice in Connecticut. Maybe Marion,
I'm
maybe
not
you're
attorney
like,
at law. I'm not attorney at
no,
all. So.
Yeah.
Christine, you know just as much, but I only practice in New York. So the one thing I will say, because I practice in the reality of what happens, right? So in the 61st day, one thing parents say is, okay, they didn't evaluate, they didn't hold the meeting, they didn't make the recommendation. It is 60 days, but I wouldn't go in there with guns blazing. I would just try to
Yeah.
move it along a little bit.
Procedural footfalls here are less
Yes,
important than they are in
exactly.
some spots
Yeah,
of the law. Yeah.
yeah,
Yeah.
yeah. So,
Yeah.
so that is one recommendation, and to really push it along, I mean, make sure you make note of the date. You don't want these things
Mhm.
going on for months and months. And I'm sure
Yeah.
Marion and I and Christine also can tell you war stories, but the the real takeaway here is keep the timeline, but also you have to be a little reasonable
Mhm.
also
Yeah.
about getting these things done.
And maybe I should just say, as kind of a broad statement as before we get too deep into this. We've got a bunch of great New York attorneys. We also have some people with Connecticut connections. Um, there is a lot of federal law that's behind this. So for those of you who are tuning in, who are listening from other states, it's not just New York and Connecticut that this applies to, obviously. I mean, there are a lot of threads that carry through regardless of state, although there are some, idiosyncrasies for each state about what stuff is called, exactly what the timeline is for certain things and stuff like that. But the broad concepts are going to be more or less the same, from state to state, with some exceptions here and there.
Absolutely. And the other thing to just, when parents say to me, I had a parent today who really wants to become an advocate. And they said, where do we start? Look at the federal rules first. We rely on them, know
Mhm.
them, and then go to your state because every state, there are nuances in every state and where the burden, who bears the
Yeah.
burden
The
is different in
procedural
every
rules
state.
and yeah, yeah.
So, parents, I always tell them, if you want another takeaway, go and read the regs, read the New York regs. They were
Mhm.
written, you know, to an extent in parent-friendly language. So when I first started
Mhm.
doing this, before I went to law school, I printed those regs because I knew I had to have some backup. So
Mhm.
I printed part 200 and 201 in New York, and I took them to the beach. I tell everybody the story and read the regs while the kids
Mhm.
played in the sand because you need to really know what your rights are.
Yeah. Yeah. So I mean the federal statutes are kind of the broadly speaking, the
Yes,
Americans with Disabilities Act and IDEA. So there are a couple federal statutes that are really relevant to all states, and then individual states kind of have their own regulations in the way they implement that, right?
exactly. Exactly.
Yeah. Well, in that vein, um, when you get a referral, and you get, and you're in the special education system, you get an IEP, right? An individualized
Mhm.
education plan. Tell us, like, what are the steps to getting that? What does that mean for people? What's the consequence of that?
Sure. So the important thing and the gravamen to me in order to get a compliant IEP, which is really that contract, right? It really lays out everything, or it should lay out everything that the district is required to provide. You need good evaluations. So one of the things I want to make sure that parents know is, remember, the district gets one bite at the apple, sort of. They get to evaluate the student in all areas of suspected disability. So what you want to make sure is that these evaluations are really thorough. And the one thing that the initial evaluations or evaluations after the fact or follow-up evaluations, a lot of times they don't have recommendations. And so you really want to make sure, A, that the evaluations are thorough, And that to the extent you can do so with a district-funded evaluation through the district, is that you ask for these recommendations. Because I think Christine and Marion, you see these evaluations that say, okay, this is what the kids' disabilities are. This is, these are some very vague recommendations, but we'll leave the rest to the CSE.
Mhm.
And the person best to make these
So
evaluations,
the CS, the CSE,
the
can you,
Committee on Special
Special
Education.
education. In New
But
York, it's a CSE meeting. In
yeah,
Connecticut, it's a PPT meeting.
yeah,
In the rest
yeah,
of the country, it's an IEP meeting. They're all the same thing,
yeah,
basically.
yeah,
so we want really good evaluations. Then the evaluations are done, and then this committee comes together, whether it's the IEP committee in New York City, we actually call it an IEP committee.
Mhm.
And then everybody gets together, and the parent has to remember that they are a part of this committee. They don't just sit back and let,
Mhm.
eight people make a decision. But then what really the law says, and again, this is not what happens most of the time in reality, is that they're supposed to develop this IEP together at the table. And the IEP is first supposed to have present levels of performance. So, I mean, it's hard with a 3-year-old to develop, or a 5-year-old to develop, how's this kid doing? But the present levels of performance, you have the evaluations, you have present levels of performance. How is he or she doing? What are the struggles? What are the talents, right? And so they're supposed to, put all this in the document. And then they're supposed to look at what the recommendations are as far as levels of service, the related services, what are the supports that are supposed to be in place? And I mean, I'm doing this like the 2-minute version of it, Mike, but
sure.
the last thing that is supposed to be discussed at these meetings, and notoriously, I'm going to pick on New York City, this happens, is people want to get to the punch. So they want to say, all right, well, where is he going to go? What's, what is the
What's the
placement
placement?
supposed to look at?
Like
But you
the outplacement
Right.
outside of a
yeah,
public
outside
school
of the
setting, or yeah,
district, or is it supposed to be a 611 class? Is it supposed to be 812? And sometimes what happens, the red flags are when they try to fit the child into the program that's available.
Mhm.
So,
yeah, yeah,
for a while, and Marion, I'm sure you and I saw this, especially in New York City. For a while, we were getting these cases where the IEP, they went through everything, they went through the flow, but realized they didn't have an 812 class available. So they
So
changed him,
what's
like,
that? What's an
like
812 or a
an 8
611?
student, 1 teacher, 1
Two aides.
assistant.
Okay,
I'm kind
yeah,
of making it
Same
up,
yeah,
with
but
611 and
yeah,
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 yeah.
1211,
yeah.
But if it wasn't available, so they changed the IEP to what's available. And that's not the way it's supposed to go. So it really is a flow of good, and I cannot stress this enough, good evaluations, get the evaluations, come to the table. Oh, and by the way, the parents should absolutely get these evaluations in advance, not the day of the meeting, not the night
at the
before at
meeting.
11 o'clock, because it's hard for parents. We've been to these committee meetings, right? It's overwhelming to begin with. So to look at recommendations and look at these evaluations, 5 hours before is just it's not possible.
Mhm.
So that's how the IEP is developed. But the last thing that should be discussed is the placement. Um, and again, the takeaways are the parents are part of this committee. They have a voice. They should always bring someone, I think. I mean, I always brought someone.
It could be a
You
friend.
you could
It
be
could
Yeah,
be a
friends.
friend,
I don't,
Yeah.
just because it's hard to really digest everything, especially when you're going in and there's going to be a problem.
Mhm.
So
mhm,
that's the way the document should be developed. And the other thing is get it soon after the meeting, because I know in some districts the families are waiting and
yeah,
waiting.
yeah,
And for me, the way I tell families is you have to treat this like you're almost like disputing a credit card. Like if there were $1,000 charge, you wouldn't sit back and wait 2 months for the credit card company to take off the $1,000. You'd be hounding them every day. You can do it nicely. You can just say to them, I need this, give me a target date, not 8 weeks. the following week, hound them again. Because the longer time goes on, sometimes things get missed on the document. You want to make sure that you watch it, you look at it, and that you make sure it's exactly what you discussed at the meeting, because then everybody has a guidepost, right?
Yeah, yeah, yeah. I want to move us along, but this is really important stuff. Let me ask one last question of you, Adrienne. Sorry, I see your cough. Sorry to
I'm
I
muting.
okay, all right, that was very skillful. What maybe as a closing thing, well, I mean, we're not closing the topic of special education because we'll keep talking about that, but as your kickoff, what would you say the biggest mistake is that parents make as they're trying to get services in the special education context?
Well, I'll say two. One thing is not to trust their gut.
Mm,
If you need to trust your gut, you're the parent. We're the parents. We really, in most instances, know what is appropriate. And the other thing is, I'm going to go back to the evaluations. Just make sure that you're getting good evaluations, and that is really the baseline. So the mistake is not going with your gut, not following up, um, and seeing this as, you know what, this is the district's responsibility. I'm just going to let them do everything and sit back. So be proactive
yeah, yeah, I
and know that you know what's best for your child.
think that's great advice. Um, So, Adrienne, thank you again. I encourage you to jump in as we go along. But Marion, I want to turn to you. I know that your practice includes special education planning, but I'd love to talk to you more about transition planning, post-secondary kind of work that you do and that we need to think about for our kids. Um, but first, tell us about your practice at Littman Crooks and what the extent of that is.
Sure. Absolutely. So I've been at Littman Crooks now for 12 years and in practicing in education law for really over 25 years. And I lead the special education department. I actually had taken over Adrienne's position. So we had both shared this position. So I agree with everything she said before. And our practices are very similar. At Littman Crooks, we have a separate elder law department and of estate planning, but we do work very and synchronized because it's very important to have an understanding of a child's transition needs when you're doing an estate plan. And it's also very important for special education to relate that to the whole family because we're talking about a lot of expenses for a whole family. And my practice since I began in 2012, a lot of it has centered on students with mental health conditions.
Mm.
There's usually comorbid disabilities as well, but
Yeah,
this is the age of anxiety, and
especially post-COVID and
and even before COVID, it was
sure, yeah.
starting. We started to see a
Mhm.
lot of school avoidance, but since COVID, it's an epidemic. And so I started also volunteering with the National Alliance for Mental Illness, and I just finished 6 years on the board and my last year as president. But I work a lot with suicide prevention, and that's we view this work as life-changing and life-saving because the wrong school placement, a student who's bullied, a student
Yeah,
who's not getting enough support, it can lead to really serious outcomes of mental health. And sometimes parents don't see it, and the district doesn't see it if the student's internalizing. So I view that as very important. And as Adrienne talked about a little bit, the district and the parents see the students very differently often. A school district has a very different aim than parents, and the law codifies that. So anyway, I can go into that more later, but my practice is geared toward really often every case I have now is really complex, I have to say. So we have 100. So we have a few attorneys and we practice in New York City all the way up to Albany. And everything from just advocacy up to litigation. I do some higher education advocacy, but we really just try to help the student and focus on the student, like Adrienne, like all of us do, because these are vulnerable young people. And so that's what I do. And at Littman Crooks.
okay. Well, so when you have a child with a disability, when when should parents start thinking about the transition to adulthood and what that means for the planning, the services they need, and that kind of thing?
Yeah. That's a really good question. I think a lot of it does come to trusting your gut and knowing your child. If your child has really significant intellectual disabilities, you're going to start very early and knowing what your
Hmm.
child can and can't do, and knowing whether they're going to be an alternate assessment in New York or they're going to achieve a high school diploma. New York still has a very rigid system where certain students cannot work through high school diplomas. And I've worked with some cases where students are designated as alternate assessment when they shouldn't be, and they should be working toward a diploma. So you should be aware of things as early as you can if your child has disabilities. I would say even elementary school, because I have 4 children and that twin boys, twin grandsons like Adrienne, and a new granddaughter who's just 6 weeks. And I saw her 3 days
Congratulations.
ago, and she has changed in those 3 days. She's smiling, and children change so quickly. And so it's so important to understand these changes. And you can't, if you delay, sometimes it just changes fast. Every parent makes mistakes. And I always say, sometimes parents say, I waited too long. And I say, do not do that. Do not blame yourself, because every parent's going to make mistakes. But the key is to, as early as you can, try to just understand what your child's needs are and get the district on board. And you're going to have to advocate with the school district no matter what, because they're going to see it differently. And that's the hard part. But I would say as early as you can, if your child doesn't have identified disabilities, you still want to develop, if you can get your child to be a self-advocate. It's so important because,
Hmm.
and I was raised in a military family, and it was always stoic. You're fine. Everything's good. And I see a lot of that really can harm students later, if that's the attitude later in school, if they just are saying everything's fine, everything's good, when it's really not.
Yeah, yeah.
Yeah, so, um,
What, so, I mean, what are transition services? Like, how do you, what does that
mhm,
look like going from the special education world to more of the
yeah,
ADA world of,
yeah.
self-advocacy and accommodations and stuff?
So it's never really enough. But under the Individuals with Disabilities Education Act, these are some mandated set of activities that are supposed to transition a student from school to post school activities, whether it's college, whether it's work, whether it's OPWDD in a group home, whatever it is. There's supposed to be a set from when the student in New York is I think it's 15 and older. That year they turn 15, and
Hmm.
then and even earlier, but they have to be on the IEP. And as Adrienne talked about, the placement being the last thing, often transition services are the thing that's not even discussed, because if there's a crisis with
Yes,
placement, it's sort of,
I
let's move on.
totally agree with that.
And
I'm
there,
from
there has
personal
to be,
experience. It's
there,
it's not
and
the last thing, it's the
yeah,
thing you never
and
get to. Yeah.
it's the non-existent thing, exactly.
Yeah.
So, and these are really critical services. And often, if it's a student who's college bound, the student will take Regents courses and go to college seminars. That's not enough. I mean, so you really need to drill down on these, and you can ask for a separate transition meeting early on, not a month before the student graduates, because by then it's almost impossible to plan. Because all these things take time. Getting services, getting students ready for college is a tremendous amount of work, aside from getting a student with OPD, WDD eligibility, or if the student has mental health conditions with SPOA eligibility, all kinds of things. So, but they're supposed to be affirmative services that are listed on the IEP with goals that can be instruction, related services, help with eligibility, vocational education, integrated employment, all kinds of things. And often they are done well. I have seen them done well. It's not that never happens, but you really have to be aware of them and don't let it just be dismissed.
Sure. All right.
Yeah.
I mean, what is there a cutoff? I mean, what is the
Yeah.
age at which, things
Yeah.
kind of flip over from the IDEA world, that special education world, to,
Yeah.
the post-secondary?
Yeah, so when a student graduates from high school with a diploma, it doesn't have to be a Regents diploma. It can be a private high school diploma.
Hmm.
This eligibility will end. That's one cutoff. So if your student's in a school where they have a choice sort of getting a diploma and they can postpone it, you may want to postpone that if you can. But on
Hmm.
the other hand, you want the student to get that diploma. or at the law is a little bit in flux now, whether it's in New York, it's at 21 or 22. Connecticut is 22. Because of a Connecticut federal law, the AR case, and then it's in flux right now in New York because of some challenges. We could spend a whole hour on that, so let's not do that.
Right.
But it's either 21 or 22 in New York. So it does cut off then, and the only thing you can really ask for then is compensatory, or you can't ask for another school placement generally.
Right.
Yeah.
And so like that, I think that is an important thing to underline here, that public school education, a free, appropriate public education is a right under the IDEA. And the post-secondary stuff is really, now we're kind of transitioning to the Americans with Disabilities Act and more in the kind of 504, Section 504 world. So we're out of the IEP world, right?
Absolutely, yes.
Yeah.
And that's a common mistake parents make. They don't always know that. And students too. No one, yeah. So that is a very significant transition. A lot of things change legally for students. There's no IEP team that's going to meet and monitor you. Have you missed your counseling, or you should be eligible for services? You have to disclose everything. Whether it's OPWDD, you have to apply for that. You have to access the services. Or in college, if you don't disclose your disability, the college has no obligation to go after you and say, "Oh, I think I noticed in your writing you may have some kind of writing disability, dyslexia." They have no obligation to do that at all. So you have to disclose, show documentation that you have a disability, whether it's dyslexia, if it's anxiety, if it's a processing issue, and then you have to apply with the Office of Disability Services each semester, not just once. And then you have to remind the professors that you have accommodations. So that's a big thing for an 18-year-old to do. And that's why I think this early advocacy, if the student can do it, is very helpful.
And I want to leave some of the planning stuff for Rich's discussion, but I think the point you made is really important. And the U has kind of changed a little bit. That is, in the special education, the U is the parent, and then after 18, the U becomes the child. What's the bridge between, like, with parental rights, and like how does the child get help from the parents even though they're now an adult, assuming they're not under some incapacity?
That's a really good question. So the student can involve the parent. The parents, people ask me that in either whether it's involuntary hospitalization or even college, what rights do I have? You don't have a lot of rights. Parents do not have rights in college. You have the right to pay tuition, to pay a lot of money, and you have the right to attend meetings. If your student lets you, if your student says, "No, I'm good, I don't want you there," they will not let you attend. So the student is in the driver's seat, and with a good relationship with your child in college, you can have an impact. And you can say, "Hey, I'm paying $100,000 a year," which is not, by the way, an exaggeration, for how much college can cost now.
I'm aware.
So hey, I'm going to, I need you to involve me, and you have to sign. We're going to talk about the FERPA, I think, later, and the HIPAA releases a little later. But that is crucial to have these releases signed.
Those are absolutely necessary. I just utilized them in the last week. And, and they are crucial to being able to communicate with everybody, if you have an emergency or, some.
Absolutely.
Well,
absolutely.
I mean, it's probably worth just making sure people know what we're talking about. And I don't think we're kind of stealing anybody's thunder, right? So you talked about the HIPAA release. So that's the allowing parents to get the confidential health information, right? The health insurance portability
and
act.
It's the Health Insurance Portability and Accountability Act, HIPAA. Everything is confidential at 18. So you will not get information from a hospital or from the college mental health services without this signed release. And each group may have their own release. And then FERPA is the Family Educational Rights to Privacy Act, which keeps educational records. Just to give you kind of a stark example, a client say, this is a fictional person, but on a weekend, they called our office and said, "Hey, I signed this AD, and could you I don't have a copy. Could you send it to me? My child's in a psychiatric hospital." And they did. I know they consented, but now they're there, and I can't reach them. I can't. They won't let me talk to them. And we were able to fax the documents over. And without those documents, even if your child has consented the hospital will not give you information because they're not going to necessarily reach out
Right.
to that young person and say, hey, will you sign this? So that was crucial for this parent to bring these documents over and say, hey, this is an adult, yes, but here's the documents. And then if they had other documents to sign, and then you can always go to visiting hours, but you don't know it's very complicated. You want to know right at the moment. If your child's in a hospital, you need information right away. And just because they're in a psychiatric hospital does not mean to the hospital it's necessarily an emergency. So that's just a really stark example of why you need those forms signed. You don't know what's going to happen. It could be a car accident. It could be, and nobody wants to think like that, but unfortunately you have to sometimes. You just have to protect yourselves and your child
Right.
even though they're adults.
Right. So it
Go
might be the HIPAA release, but it could be a broader, power of attorney or something
Power of
too, right?
attorney
Or healthcare proxy.
I think it should include, they're called advanced directives to do all of them, to
Yeah.
do them together. I think it's a good
Mhm.
idea to, at 18, you're an adult. Remember that, even if you have a disability. And I
Yeah.
think that's hard to understand.
It's shocking to parents to think of that.
Yeah,
You're looking at your
it is.
18-year-old and saying you're an adult is kind of a
Yeah.
leap. Yeah.
Yeah.
Okay. Well, Marion, thank you. I want to make sure we
Yeah.
get to
Of
Rich.
course. Let me just tell you one
Yeah,
thing.
please.
Okay, I know the most important thing people get if you're transitioning to college, get tuition insurance because just keep in mind that only 41% of students graduate in 4 years. And for that, tuition insurance can make a big difference if your child has to leave for either any kind of condition. And, if a child has a disability, it may just be too much the first year and you may want to have this protection. So just one little piece of advice. Okay,
Yeah,
then I'll let you move on.
Great
Yeah.
advice. Thank you. So Rich, I'd
Yeah.
love for you to talk more about or tell us about your work at Wealthspire, what you do for clients. Just as a bit of an FYI, I think we already have a few questions about special needs trusts.
Okay.
So we ought to make sure we cover that. I know we have a few things that we want you to talk about, but if you could tell
Sure.
us about your work and maybe include special needs trust in that general description too, we'll dig into that more.
Sure. Yeah. So I was a former practicing attorney since 2011. I decided to take a lifetime break from that in 2018 when I joined Wealthspire. So at Wealthspire, I basically work with our clients to help set up estate plans, work with their attorneys the attorneys would draft the documents to help implement those estate plans. And we just want to make sure that we're transferring wealth in the most tax efficient way and making sure we're doing it in a way that protects the wealth for those heirs and for that potentially child with disabilities. So that involves a lot of back and forth, meetings with clients' attorneys. And a big part of that, obviously, is working with the special needs planning part of it and making sure that the parents' estate plan is leaving things to their children either through an inheritance or maybe through lifetime gifts in a way that doesn't jeopardize their ability to be eligible for government benefits. There's a lot of needs-based government benefits that children with disabilities can be eligible for, but they can't have a lot of resources or assets in their name, and they can't have a lot of income in their name. So that's where that planning comes in to make sure we're giving those children the ability to access those assets without jeopardizing their eligibility for those benefits.
Right. And if I can add a little bit to that, I mean, it's not just about preserving family assets from a numbers standpoint and preserving wealth. It's also about access to those programs, right?
Yes.
Because if there are a lot of programs that are really useful, valuable, that if you don't qualify under that needs test, it's very hard to find a substitute for them.
And that could include day programs, housing,
Yeah.
respite, a number of different programs that,
Yeah.
and that's a great point that it's more about what, the state can offer you in terms of services for your adult child with needs and less about, I mean, you hear the word trust and you're like, oh, but I don't have any money to protect, that's not what it's about. It's about, being able to preserve access to those programs.
Yeah. Yes. I mean, to be honest, our clients, because of what we do, have assets, and so we need to protect those assets just to, protect other kids in the family and everything else, and preserve that inheritance, or frankly, the assets of the parent too. But
And I'll add the
yeah,
thresholds, the
mhm,
limits for those benefits are pretty low. So even if
yeah,
you
Yeah.
feel
yeah.
like you don't have a lot of that money, in the government's eyes, you have a lot of
You
money,
have a lot of money. Yeah,
basically.
And
exactly.
Yeah.
Yeah.
can I just add one
Please,
thing
please.
that for many of these programs in New York, even if you didn't want to access the government benefits because you say, you know what, I have so much wealth, I can pay for it privately, they will not take the child or the
Exactly. It's
adult
access. Yeah.
without the access.
Yeah.
So you're almost forced to do it
Right.
anyway. So, I think it's a really important point that you need to make them eligible.
Yeah.
You
Yeah.
need to.
And look, there are some instances where you can decide to pay privately, even if you are Medicaid qualified. For instance, if there aren't enough Medicaid beds, you may still be able to pay yourself. So you can always like kind of cough up the money in a different way if you've done a good job of protecting assets. But Rich, how would you do that? Right? Like, how do you go about accomplishing that protection?
Yeah, so there's two main ways. I guess since we're getting questions about special needs trust, I'll go that way first.
Sure.
So one way is the special needs trust, and that's a trust. So let's take a step back. A trust is basically a separate legal entity that can own assets that you can transfer assets into. So the person who sets it up and funds the trust would be called the grantor. That typically would be the parent or maybe a grandparent or other family member. Then you have a trustee who helps manage the assets in that trust and
Mhm.
makes decisions about when those assets get distributed, how to invest those assets. And then you have the beneficiary, in this case, in the special needs trust context, which would be the child with the disabilities. And every state has their own unique statute as to the special language that would need to be
Mhm.
in the special needs trust. So wherever you live, you'd want to hire an experienced special needs planning attorney who knows that statute well and knows to include that magic language in the trust so that it's honored as a valid special needs trust in that state.
I want to poke at that a little bit
Yeah.
because I think in some respects this is mind-blowing to non-lawyers because
Yeah.
it sounds so stupid. When when you like in Connecticut, there
Right.
was a case that I think the trustee had sole and absolute discretion. Those were the words in the trust document.
Okay.
And the court said, no, 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 that doesn't mean really uncontrolled. We can still look at that and decide whether there should be a distribution, which blows up the special needs part of it. So in Connecticut, you need to say sole, absolute, and uncontrolled discretion, all three of those things. And
Yeah.
it's like magic words, like you
Yeah,
said,
it
right?
really is.
It
Yeah.
which is weird, but that's
Right.
just the way things work. Um,
Exactly. You have to specifically reference the state statute that essentially codifies the ability to create special needs trust in that state. So yeah, definitely need an experienced attorney and not the guy who does all types of law because that
yeah,
guy's
yeah.
yeah.
So you need a Marion, you need an Adrienne, you need
Yep.
somebody who does this, not not just your uncle who does, who
Real
does
estate law.
door law. Yeah, who like whatever walks in the door, that's the law they do. That's not the person you want to do. You want to use
Correct.
for this. Yeah.
Correct. And the
Um.
way and the way the
No,
special
go.
needs trust works is because it's a separate legal entity, it is not owned by the beneficiary, by the child with disabilities. So it's not an asset of the child. It's just a pot that the child can basically access through the trustee if they need, and it helps to supplement and enhance and improve their life without jeopardizing their eligibility to get those benefits that we were talking about earlier.
And I know
Rich,
you
I
know
had a
this, but
question.
I'll.
Sorry,
Yeah,
Yeah,
go ahead.
from
Go
the
ahead, Chris.
audience. Are special needs trusts portable that can they be moved between states?
Yeah, so it's typically you'd have to work with both states' attorneys to there'd be something what's called decanting, and typically I think it should be flexible enough or drafted in a flexible enough manner where that decanting is possible. And decanting is basically pouring over from one trust, let's say in New York, and that person has now moved to Connecticut to, let's say, a Connecticut trust that has that special Connecticut language, because the New York trust the New York Supplemental Needs Trust may
Mm,
not have that language that Mike was describing just
mhm.
now, that Connecticut wants. So
Mhm.
you'd want to have a trust that's, again, an experienced attorney would know how to draft it in a flexible enough manner that has like the ability to decant to a new trust in a different jurisdiction that's still honored as a such special needs trust in that jurisdiction.
And on that
Right.
same note, I believe guardianship needs to be transferred between states as well. Marion or Adrienne, do you want to weigh in, or anyone on that guardianship?
Well, I mean, I'll say this, that if you're moving from one state to another, you should as soon as possible, even though there's full faith and credit, and most states will honor, at least in the interim, the guardianship from one state, they should really transfer the guardianship. And it's actually a bit easier today because many of the states, and I forget how many, um, there's an act that allows the guardianship to be transferred pretty easily. So it's not as if you have to go back and apply in state two. And we've done it,
Mhm.
I don't want to say a lot, but we've done it, and it's really done on the papers. Marion, maybe we
Yeah.
want to, am I forgetting anything?
Absolutely. And in New York, it can become increasingly difficult to get a guardianship that's not a strict 17A, which is the for students with intellectual abilities. But we have something now called a supportive decision making in New York,
Mhm.
which is not, I don't think, in Connecticut. That's a whole other
Mhm.
area that we don't
No, I
have to
think we do have
discuss
supported
right now, but
decision
it's
making in
not.
Connecticut. I think we do have
Oh,
it in
you do?
Connecticut.
Okay. Okay.
Yeah.
You do? Okay.
At,
Well, that's
at the
good. But
same
it's still
time,
not even, it still hasn't. Go ahead. I'm sorry. But did you want to
go
go
ahead,
ahead,
Marion. I
Michael?
didn't mean to interrupt you. Go ahead.
Oh, no, I was just going to say it can be hard to enforce that. So, in the absence of a guardianship, you should have the power of attorney if the person has capacity, as well as the advanced directives.
Yeah. No, that absolutely.
It gets
You know,
to be a tricky issue. We call them the in-between students. It can be hard, the ones who don't qualify for 17A, but need a lot of protection.
yeah. I mean, there are a lot of kind of high-profile guardianship cases right now, like the TUI or like the blind side guardianship issues and
Mhm.
Britney
Yep.
Spears and that kind of stuff. I mean, once you have a guardianship, there you lose some level of control to the court, and you've
Mhm.
got to realize that there's now another party
Party.
in it, an interest there that you've got to manage.
Mhm.
So that's typically a last resort, although it's certainly for people with significant disabilities, it becomes necessary.
Rich, I had
Rich,
a couple other questions, sorry,
yeah, I,
from the
Yeah.
I want to make sure we get to able accounts and
yes,
stuff
and then
also.
I had some other questions for Marion and Adrienne about transition and OPWDD. So I don't want to
Okay.
forget that, and because everyone's
Okay,
being so patient.
because Rich, I think you said one way
Yes,
was special needs trust. I think you were going to say the other way
that's
was
right.
able accounts. So why don't we give you a chance to finish up your list?
Okay, so the second way is ABLE accounts, and that stands for Achieving a Better Life Experience Act. And that's codified under Internal Revenue Code Section 529, capital A. And it basically allows people to set up tax advantage savings accounts similar to 529 for education, basically. But 529A or ABLE accounts are savings account for people with disabilities. And they're tax advantage in that they can grow tax-free, and any distributions that are made for what's called qualified disability expenses are also tax-free. So you can set up an ABLE account. State by state has their own type of different administration as far as how they set it up, usually through a state website, similar to, again, to 529s. The ABLE account has some limitations as far as how much can be contributed each year.
Mhm.
So it's tied to the federal gift tax exclusion, annual exclusion. So this year in 2024, it would be $18,000 from any source, all sources combined, that
Mhm.
could be contributed to an ABLE account each year. So there's limitations as far as how much you can add each year to an
Mhm.
ABLE account, but expense distribution can be made from an ABLE account for like education, housing, transportation, like employment training, any type of assistive technology or health wellness services not covered by Medicaid. Even like financial management, legal fees, things like that. All those types of expenses are qualified disability expenses that would be tax free.
And there's a limit too on totals, right?
Yeah,
In terms
that's
of
right.
what's non-countable for Medicaid / Social Security purposes.
That's right. So able accounts typically you want to keep them relatively low because once they exceed $100,000, anything above the $100,000 jeopardizes your eligibility for what's called SSI. And SSI is basically the federal government giving you a monthly allowance if you have very low income. And the maximum SSI benefit currently in 2024 is about $930 a month.
And
So yeah,
and the
go ahead.
rules for SSI qualification are very similar or kind of coextensive with Medicaid qualification. So those are the ones we're kind of worried
Yeah.
about most of the time.
Exactly. And just a talking point to where we were talking about the low thresholds and how some folks who think they have no money actually do have money. You can't get SSI if you have more than $2,000 of assets. So that beneficiary who has more than $2,000 of assets in their name is ineligible for
Mhm.
SSI. Able accounts, supplemental needs trusts are exceptions to that, except for the fact that if an able account exceeds $100,000, to the extent it exceeds $100,000, it will eliminate your ability for SSI until you get back down below $100,000 on that able account.
Right.
Can you have
Christine, you said there were some other. Sorry.
yes, can you so can you have an SNT and an able account at the same time? That's question number one. And question number two, can your SNT contain assets like a house?
The answer is yes to both.
Okay.
So yes, and in fact, a lot of clients do have both because the able account, we have to remember, or I should point out actually, whatever remains in the able account at the beneficiary's passing is subject to state Medicaid claims.
Mm-hmm.
So we definitely don't want that able account to get too big
Mm-hmm.
because it's
Because you're going to lose the money that's in there.
exactly. Medicaid, every state recovers the Medicaid expenses they disperse out, and that's a place that they can recover those funds from.
Mm-hmm.
So typically you'll have an able account that's a little smaller, and the able account can only have cash that's invested.
Mm-hmm.
Whereas the special needs trust, you can put a house in there, you can put stocks, you can put cash, you can put
Mm-hmm.
other types of illiquid
Anything
assets.
like that. So yeah.
Yeah.
Exactly.
Yeah.
So it's a lot more flexible. Yeah, go ahead.
There are some complications if the house is where the beneficiary is living,
Correct.
right? Because you can have like imputed income from I'm living there rent free. So
Right.
you've got to like worry about that a
Organize
little
that.
bit.
Yeah.
Yeah. And I also, and I don't think we've got the time to get into this. We've been assuming that all the money is coming from a third party, that it's a third party special needs trust.
Yes.
There's a a pretty big cadre of disabled individuals that got money from some kind of a settlement, some medical malpractice injury, some issue that caused the disability could cause them to have assets in their own name, which then they would want to put into what's sometimes referred to as like a payback trust or some other kind of first party special needs trust where they're putting their own assets in, but they can use that for kind of supplemental help. Christine, you said there were some more things for Adrienne and Marion.
I have I have one more trust question, which is, can the grantor and the trustee be the same person? That was one.
So the answer is yes. So there might be some limitation. It depends on like from a tax perspective. So the answer is yes.
Mm-hmm.
But if you're trying to do it also from an estate tax planning perspective, because you have a highly taxable estate, then you would want to name a different person potentially as trustee because of just estate tax rules. Probably not for this seminar, but just knowing that if you have like a taxable estate, and that means a person currently in the US with a $13.61 million estate, that's a situation where you might want to have somebody else act as trustee for the estate tax reasons. And
I think there
also,
are also issues during minority too, right? If you have an obligation to support that beneficiary, then you've got a potential problem there too, I think.
Correct. And typically you'd also want to name a younger trustee anyway, foreseeing your disabled child will live longer than
someone
you.
younger
So
than
you want that trustee to be in the
Yeah.
same lifespan as that beneficiary.
And frankly, that's one of the reasons we created a trust company in the first place, to act as that backstop for people, because it comes up a lot.
Right.
Is there a time for, the SNT to be set up, and like an age? Like, does it have to be set up by age 18 or 22?
So there's no age that it has to be set up by. You can do it during your life. So I could set up a special needs trust for my daughter right now if I wanted to. A lot of folks do it through their wills, where they basically say, all right, when I pass away, I want my three kids to get 1/3 equal shares, but I want my disabled child share to go into a special needs
Right.
trust for
And then it would
benefit
sort of
rather than
waterfall
outright.
into that. Yeah.
Exactly,
Mhm.
exactly. And you also want to make sure your beneficiary designations on like things like IRAs and life insurance policies are kind of buttoned up so that
They're the
the
trust, not the
disabled,
person. Right.
Yeah.
exactly,
Right.
the disabled child is not receiving things outright,
Right.
which could mess up her eligibility for these
Yeah.
benefits amount.
I mean,
Yeah.
this is an area where sometimes you're not exactly even, Stephen, for everything, right?
Mm,
Because you need to, like, for a disabled child, you might absolutely need a certain amount of money because
yes.
because you've done the financial planning and modeling that we need to fulfill this need, right? And the other two kids might have less specified needs, so you're willing to let them kind of
Right.
ride up and down. So you might have like
Right.
a a fixed dollar amount go to the disabled child and the special needs trust for them, and then like you'd have the other two kids split things,
Right.
Split assets
after
that
that.
might fluctuate in value. Right.
Yeah,
Right.
or you
Exactly.
might say IRA stuff goes to the non-disabled kids because that's a more difficult thing to plan around with special needs trusts, and we might use the the other assets to fund the special needs trust. This is one of the areas too where we don't sell insurance. That's not what we do. We don't get paid on insurance sales. I always feel like I have to say that every time I mention insurance, but this is one case where permanent insurance can actually be helpful because I have this need. It's not going to go away. I've got to make sure it gets funded come hell or high water. So I'm going to fund that with insurance. And then I'm going to let the other two kids, in our example, get whatever is left after that.
Yeah.
I have two questions, just going back to the, kind of the transition issue. Do you recommend that, is the recommendation that transition services be listed on the IEP as the students near transition, or how should you approach, the transition process?
Yes, they have to be listed on the IEP at the year the student turns 15 in New York. I believe it's 15, I think. So they have to be. It's a mandate under the IDA. So absolutely, the more specific, the better. And so, as I said, sometimes school districts aren't as specific as they like, but they generally do. Even if they don't have a detailed discussion at the meeting, we'll write something. They'll make something up. No,
Yeah.
but they will at least ask the students' preferences. What do you want to do, and things like that. They should maybe do. They should be doing more than they're doing. But absolutely, it should be a separate section. There should be both goals as well as transition activities.
And if a child has a waiver and is receiving supports through OPWDD, does that continue as they move into adulthood? Are there any additional considerations that, that one needs to think about as the child transitions through adulthood?
Yes, the waiver, the OPWDD services will continue. It won't be able to be through self-direction. That's a whole process that the student goes through to get funding for a budget, and then it will start sort of advocating for what is going to work for them. Anything from a group home to day hab to even funding for college. Sometimes there's a lot of things it can cover, but it has to be through that self-direction. The hardest thing with OPWDD we're seeing is there just aren't a lot of providers. And there's a long wait list for any residential. So there's definitely a shortage for things, but
Right.
so that's the difficult part. Adrienne, does that align with what you?
Yeah, oh, absolutely. The only thing I would add is that if it's a younger, if someone applies young before they're 8, there's that provisional eligibility. So what happens is at 8 years old, OPWDD comes in and reevaluates whether the young child is qualifies for long-term waiver services. So what we're seeing, and I'm sure Marion, you're seeing it too, is it goes in ebbs and flows with these denials. And right now during COVID, they didn't really look at the provisional eligibility, but now they're starting. So we're seeing some denials where I never saw them at 8 years old. So,
Yeah,
yeah, so it's a little different.
absolutely. You're right. Mhm.
Yeah, the landscape is just, it's different. It's a little different.
I had another question. If you have a child that's been in, an independent special education school, let's say, and has not been in, in public school and is about to graduate, never really had a sort of understanding of, what the state, or the local district, provides. What's the best way to, to kind of attack that and try to understand this and educate yourself as the student starts to approach college? How would you approach that situation?
Yeah. I don't know where the student's located, but that's a complicated question. And I do think it's important to, even if it's close to graduation, reach out to your local school district and figure out if don't necessarily agree to graduation. We have seen that in some cases. People come to me after a student who has, an intellectual disability has managed to graduate or just be pushed along through a private school. And then they have a diploma and then they're not going to be eligible for more services. So that can be a real disservice. So I would recommend, if you finding an attorney in your area and a special education attorney, and at least having a consultation just to figure out, because time is of the essence. That I don't know enough of the circumstances to say what the right thing to do is. But a lot of people always assume private is better and private's going to do it all, and you can't privatize everything sometimes, and private is not always better. Private schools are not always good at transition. So it can be better, but not always. So there's a lot there. So I can't really answer that exactly, but I would say to get informed on it. Yeah.
Yeah.
Does that make sense to you, Adrienne? Does that?
Yeah, no, absolutely. Marion said it. That is one of the most complicated questions, is when a family comes like right at the end or the child graduates. So I agree with you. I agree 100%.
I'd say also that and I know this is true in Connecticut, and I think it's true in other states too. Increasingly, public schools are trying to set up kind of special education schools inside them, and they bring in a consulting service to run kind of a non-outplaced solution, and those are, I think, particularly hard for parents to evaluate because it depends on who the vendor is, and and that can change year by year, which I know from experience.
Yeah. Yeah, it can be complicated. There's so many variations that we don't know exactly, but there are, so we'd have to evaluate each situation individually. But I think the main thing is just if you can talk to somebody just to get more information, because the school district might not always tell you.
Yeah, Marion, I think your point is excellent. If they can at least do the consultation, and Marion and I know we have a lot of work, so it's not about, generating a consult, but parents need to really be informed. And I think, going to somebody that really can address something quickly, is really key.
Is it true that, a family with more than one child with special needs can receive SSI without income limits?
What there's always income limits with SSI. There's always going to be income limits. The issue really is if the child's under 18, right? And there's no waiver, there's no Medicaid waiver, there's no extraordinary circumstance, the parent's income is always going to be taken into consideration. When they turn 18, it's not going to go although if they live home, there's going to be some allowance in the household. So there's always SSI is a mean tested benefit. So
Yeah,
we're always going to look pre-18
at the means,
at the families.
At the family's means.
Yeah, we might be talking about a Social Security retirement benefit or some other benefit.
Yeah, that we're not.
Yeah, well, there's SSDI
right
for adults with a work history who have become disabled, and there are different rules there. So you've got to make sure you're talking about the same
Right.
benefits
Correct.
Because you can get SSDI as a survivor, like you can get
Yeah.
it's that crazy name, but survivor benefits, even though the parent's still alive.
Right,
But
right.
get on the you get
Mhm.
you get benefits on that parent. That's different, and that's not means tested. So you can have $1 million
Right.
and get that benefit.
That's if the adult is, the adult
Working.
parent is disabled after working, and then
Right.
the benefit goes to the disabled child. Is that how that works?
Part of the benefit would
Will
go to
go.
but it's really a lot of times it happens when the adult retires and they get Social Security benefits, and the kid, the child or the adult child gets SSDI as an adult disabled child, if that makes sense.
Yes,
So
yeah.
it's either the parent got SSDI, the parent has Social Security benefits, and as a result of that, the individual with disabilities, whether it's a child or an adult child, gets benefits off of them. And again, I always say to parents, the website for the Social Security Administration is really a good website and will give the right
Yeah.
a lot of information. So, I encourage parents to do it. And if there is an issue with, again, if it's not as straightforward, like my daughter Jordan it's very, plain vanilla that she's going to get these benefits. But if you have a nuanced case or mental health issues, I would say, right, Marion, and they're, you have to apply, that's when you see somebody that does this work.
Yeah, I
Uh,
mean, you could have somebody in midlife who has an acute mental health, issue that means that they've got a work history up until then and credits that they can use on their own credit, right? On their own
Yeah.
And
Social Security.
that's not means tested, they
Yeah.
don't
Right.
they don't have to meet the threshold
Right.
for any
Yeah. I
threshold.
think you have to
So
work for at least 10 years in order
Yeah.
for that to kick
Yeah.
in. Yeah.
Yeah.
So, yep.
Yeah.
Great.
But I mean, you could have a 30-year-old kid, as a parent, you could have, a child in their mid 30s that suddenly, takes a turn for the worse.
Right.
And now you've got to help them, and there's a different set of considerations then.
Yeah.
All useful in terms of reaching out for a consultation to anyone on our panel who is an expert in in this area. I think you all, thank you all for providing just a tremendous amount of information this evening. I've said it, before, and I'll say it again. Every time we do this, first time, second time, third time, I learned something new, and something I'm, usually not expecting. So I really appreciate, Mike, for moderating this great panel, Rich, Marion, and Adrienne for participating and sharing your knowledge and wisdom about, these incredibly important topics for families that have children with special education and special needs in general. My name is Christine Lai. Thank you so much for joining us this evening, and everyone have a great night.
Thank you
Thank
so
you.
much.
Thank
Thank
you.
you,
So
everyone.
much,
Have a good
everyone.
night.
Take care.
Bye.